right. So howdy, and again, thank you for being here for the Accessibility in Aggieland webinar series. My name is Megan Orstag, and I am here to help with facilitating this session. This session is called ADA in the Workplace, and this is the Americans with Disabilities Act overview. And our presenter today is Andrew Barna Jr. from the Division of Human Resources and Organizational Development. And Andrew is a director of the Employee Relations. The Employee Relations is a department within the Division of Human Resources and Organizational Effectiveness. The Employee Relations Department provides strategic human resource management and supports to academic and administrative departments within the university to ensure compliance with all federal, state, local laws, and all university rules, regulations, and procedures. This department is responsible for handling all staff ADA accommodations, disciplinary matters like terminations, appeals, complaints, alternative work locations, administering the Family Medical Leave Act, FMLA, policy guidance, staff arrests, drug testing, reductions in force, workers' compensation, and unemployment claims. And so without further ado, I'm going to hand over the microphone to Andrew so that he can walk us through ADA in the workplace. Thank you so much, Andrew.
Not a problem. A pleasure to be here. Thank you for that very nice introduction. My office basically handles all personnel matters. So feel free. I will certainly be putting my email and contact information at the chat at the very end. If you have any questions regarding this or anything else, please feel free to reach out to myself or my staff. We'll be more than happy to address any questions or concerns you may have. With that, I'm going to start on an overview of the ADA. Kind of different things we're going to cover today is what is the law? What is considered a disability? What is a reasonable accommodation? How does the process work? Is it a confidential process? And who do I contact if I need help with anything related to the ADA? What is the law? There's actually two sections of the ADA, both enacted by a President Bush, just not the same President Bush. The first enactment was in 1990 by George H. Bush. And with that, it really established a framework for the ADA. But that mainly focused on issues or disabilities regarding being able to perform certain bodily functions. George H.W. Bush in 2008 further expanded on the ADA to include not only issues or limitations individuals have, but covered more of the medical conditions that cause those limitations. ADA accommodations are covered under System Regulation 080102. This is civil rights protections with individuals with disabilities. Again, the regulation mirrors the ADA. It just kind of boils it down and makes it more streamlined for application within the university. It explains how to report a condition, what the interactive process should look like. It outlines what medical documentation is required and helps further refine what is a reasonable accommodation. What is a disability? Disability is a physical or mental impairment that substantially limits a major life activity or a majorly bodily function. Included within there is a history of disability or someone who is regarded as having a disability. Basically, what I did was pare down the definition from the law into its section. So the first, it has to be a physical or mental impairment that substantially limits a major life activity or major bodily function, which is defined in the law. And this can also include people that are regarded as disabled or have a disability. The law defines a major life activity as standing, sitting, seeing, breathing, walking, pulling, thinking. The list is pretty extensive. I was hard pressed to think of anything that is not considered a major like activity that's not covered under the law. As for bodily functions, it is equally as exhaustive. It covers everything from your head to your toes and everywhere in between, from your muscles, skin, everything. So it really is encompassing of not only activities, but of the human body. A reasonable accommodation is a modification to the work environment or the way that the work is performed that allows employees to perform the essential functions of their job or access to the benefits and privileges that others enjoy. The two main characteristics of a reasonable accommodation is an employee still must perform the essential functions of the job. So you are not limiting any portion of their job responsibilities, or you're not substantially limiting the qualifications for those job responsibilities. So people can't walk in and say, well, I'm only, for example, in my situation, 5'7", and I feel like I should be able to play Major League Baseball, and you need to find an accommodation for me so that I can compete and at the highest level like that. That's not changing the qualifications. If for whatever reason a job had a requirement, and kind of where you see this a lot is sometimes with police or certain job functions, employees may have to take a test or meet certain qualifications or criteria to seek employment in that particular field. For example, police may be required to run a 1.5 miles within 12 minutes. Now, if someone has a disability, they still may be required to run that 1.5 miles, but they may be given a little bit extra time to accomplish the 1.5 mile run. Or if someone has a little bit of a learning disability and part of a requirements for the position, they have to take a entrance exam, so to speak. They may be provided additional time to complete the exam, and then their score is based and evaluated given others. So a reasonable accommodation is not saying, hey, I can't perform X, the job requirements for a position are A, B, and C. And someone says, I can't perform A, but I can perform B and C. Therefore, I'm willing to perform D. Therefore, I should be get that position. No. What it says is, what do you need to be able to meet the expectations to perform A, B, and C function within the job? Or access or benefits of the job would be a situation, well, I can do the job, but I have difficulty getting to the office space to do it. I'm in a wheelchair. I'm in the office is on the second floor. There's no elevator system, or there's no ramp to allow me to get into the building, things like that. That's where the ADA comes in and says, we have to provide a reasonable measure to ensure that the person is able to the access and benefits and privilege of doing the job, access to the work site, access to their office. It can be done in a wide variety of ways, moving their office to their first floor, installing an access ramp would all be reasonable under the ADA. Any questions on what the law is, what a reasonable accommodation is? I kind of went quickly through there. This is where there's no bright line test of what's reasonable or what an essential function of the job is. That's where it really leads to the interactive process. But please, I'm welcome to take any questions, issues, concerns you have, anything. Okay. ADA accommodations, reasonable accommodations. Who approves a reasonable accommodation? Reasonable accommodations are under Texas A&M and under the system regulations are approved by the department. If for whatever reason, reasonable accommodation in the department's eyes, they can, I don't want, denied is not the right word to use at this level, cannot accommodate an accommodation, either it's too costly or you don't feel it fits within what a reasonable accommodation is. What they're looking for is not really an accommodation. What they're looking for is a limitation or removing some job duties. You would work with my office. We would start with the interactive process. We would meet with the employees to further discuss what they're looking for, why they need it, and kind of what we can do to help them, short of what they're asking for. Once we do that, we've had pretty good success in my office. There's been very few outright denials of an ADA accommodation. Generally, what we can do is work through to find maybe something that works for both the employee and the department. And a lot of times what we'll do is we'll do it on a trial basis and then revisit maybe in a month or two down the line to see how the accommodation's working out. If it's working out well for the department as well as the employee, are they able to perform those functions of the job that they're required to do? Reporting of disabilities can take many, many different forms. It can be verbal, it can be in writing, it can be an email, it can be a text message. In a lot of situations, if they request FMLA leave, sometimes that can automatically be converted to an ADA type situation, depending on the nature of the leave, the nature of the medical condition, and any restrictions that are placed upon their return to work. So it can go many different ways. Your job duty / responsibility, I always say for supervisors, if you have an employee who's may not be asking it for by name, but is kind of alleging, hey, I have a medical condition, I really need XYZ equipment, or I need XYZ consideration or modification to do my job. My advice is always involve HR, whether it's my office, reaching out to your HR liaison to kind of put them on notice. And then the HR liaison or my office, what we'll immediately do is reach out to the employee, provide them with the documentations. There's forms that we need to submit. There would be an employee's what they're looking for, a request. And then there's also a medical verification form from a physician stating, yes, they have XYZ medical condition or XY disability. And in their opinion, ABC accommodation would allow them to perform the essential functions of their job. Realistically, without the ADA form, either submitted by the employee and the medical certification, we really don't have to entertain any ADA request. Not to say we should just turn a blind eye to it. We should be encouraging them to submit the documentation, providing the documentation from them. But at a certain point, the onus is on the employee to do their requirements under not only the law, but under system regulation. Any questions? I kind of covered a real lot with the reporting.
We have some questions in the chat function that I would be happy to read to you.
Sure.
I had a few that were private message, so I'm going to read those out loud. What is my role as a supervisor and or staff person in supporting another colleague or person I supervise with a disability? And another, I'll stop there.
Okay, I'm sorry, you kind of cut out a little. I don't know if it was on my end.
It's probably mine. It's rural internet. Let me read that again. It's what is my role as a supervisor and or staff person in supporting another colleague or person I supervise with a disability?
Your responsibility is we're not really obligated or especially a supervisor to ask an individual if they are disabled, or it's kind of crossing that line. But what we can ask is probing questions. Is there anything I can do to help you? I've noticed you've had difficulty or you're struggling with A, B, or C. Is there anything you need, anything I can help you to improve on that? And unfortunately, generally where the rubber meets the road is when you are looking to get proactive with their performance. Where performance is starting to struggle, you've kind of had informal discussions, it's not really going anywhere. You reach out to my office, to the HR liaison, say, hey, I'm having difficulties, they're not performing well. I need to start the quote unquote disciplinary process, whether that's a memo of expectation, a PCA, and then the person has a tendency to open up and divulge or ask for help. So our responsibility is more as a supervisor, as a colleague, is if we see it, kind of ask in a nice way, not using the D word or anything like that, asking, hey, is there anything I can do to help you? Do you need anything to help you achieve or be successful in your current position?
Thank you. And I think you answered the next one. And there's a question in the chat function that combines the third question. The question was, to whom should this be reported, the supervisor first? Question mark.
If you're as a colleague or seeing or heard that an employee is saying, I'm really struggling with this, my medical condition, or my, if they actually use the disability word, that employee has one of two ways. Reach out to the employee and say, hey, I think you should reach out to HR. They can help you. There's ways to go about it. You can get an accommodation. No, 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 I'm fine. I'm fine. I'm fine. I can get through this. I'm just going to buckle down and get through it. I'll just work a little bit harder. If that's the response you're kind of getting from your colleague, then making the supervisor aware. Hey, I heard this. I think it's something that um, you should bring to HR, or the person can go right directly to HR and say, hey, person confided in me. They're reluctant to come to you, but there's an issue. They need help. And then it's kind of on HR to reach out. Again, we can reach out and try to be as proactive as possible, but ultimately it is up to the employee to initiate the process.
Thank you. And then the final question in the chat right now is regarding accommodations. Sometimes you hear folks say, well, we just don't have XXX, the person with needing the to do the task or that task that will be reassigned. Is that considered an accommodation instead of accommodation to provide an equitable use slash ability to do the task? Thoughts?
And thoughts. Okay. Reassigning a task because a person is unable to do it is not a reasonable accommodation. Providing the employee a mechanism or additional time to perform that task is completely reasonable. If they are having difficulties reading their computer because their eyesight is diminishing, getting them software that will read emails, especially PDFs. Sometimes PDFs are rather difficult for people to read. And it's very difficult to enlarge the font in a PDF to read it. Getting them software that allows the PDF to read it to them is a reasonable accommodation, something that we should be exploring. I mean, quite frankly, the software is available within the university. I've seen it. I haven't used it, but I know it exists. So that's a relatively quick fix. If it's something, and this is kind of a good leads into another segment, just because the reasonable accommodation will cost the department, say, a few $100s or a few $1,000s, and you don't have that money in your budget, it is not reasonable for you to deny it due to the fact you don't have funds, especially given the size of Texas A&M University. What the courts look at is not the reasonableness of a department funding that, but it's the employer in question, the employer being Texas A&M University, which is a $2 billion organization. So the fact it's going to cost a few $100s for, and these are just specific examples I've seen, where I've had a department say to me, we can't afford buying new vacuum cleaners for the employee. How much a vacuum cleaner costs? Well, they can't do the one that straps to their back because they have a back issue. They want to get one that's on wheels and moves around. It's easier for them to move around. That's a reasonable accommodation. And the fact that buying a new vacuum cleaner may cost the department $150, $125, is something that we need to do. It's not valid for to say, no, we just bought a new vacuum cleaner for her. We want all our employees to use the backpack. It's got the best suction ratio, whatever the excuse is. That would not be reasonable, especially if they got documentation, they have a back injury, and they can't put it on their back. Pulling one that's on wheels, similar to a shop vac, is absolutely reasonable.
Thank you, Andrew. And we have one more question come in. The question is pairing them up with another employee a reasonable accommodation?
Generally speaking, no. However, it could be for a limited time period. For example, if they have some type of learning disability where they need someone to, it's one thing to tell someone how to do it and maybe even show them how to do it, but having someone have them walk through the process, maybe for a week, showing them this is how you do tasks, so they can kind of build that repetition. So it almost becomes more muscle memory type situations. That could be a reasonable accommodation, but completely assigning someone for the foreseeable future in more in an indefinite situation, I'd be hard pressed to say that's a reasonable accommodation, because realistically, you have at that point maybe 1.5 people doing a job that otherwise one person should be able to do. Now, again, it could be reasonable for a limited time period, training purposes, things like that. I would be okay with that, but indefinitely where the person needs to be paired with someone else, that's, I don't think is reasonable over a long term.
Thank you, Andrew. All right, that's all for now.
Okay. We'll move on. Denying accommodation. If an alternate accommodation is not available, and that's kind of where we work through the interactive process, where the department looked at it and goes, no, we really can't accommodate this, or it's too cost effective or cost prohibitive. We can't do this. We start in the interactive process with employee relations, where we kind of try to mediate, find a reasonable solution, or sometimes quite frankly tell one party, whether it's the employee or the employer, you're not being reasonable. You have to do this, or what you're asking for is just completely unreasonable. You're expecting to keep your same pay without doing any of the essential functions of your job. We would say, hey, we couldn't find a reasonable accommodation. We would write it up and then bring it to the ADA administrator, and they would have the ultimate say on whether or not it's reasonable to deny the accommodation. Generally, again, very, very few have I bought there. Actually, one since I've been with the university, and the ADA coordinator sided with the department saying it was unreasonable to grant that level of accommodation. Once that's done, then we being employee relations, will coordinate that decision to all the parties. And there, again, a lot of this is done by forms. We have forms available on our website that kind of lay out how the process works, signatures, everything else. It's more of a just filling it in and then submitting it. Any questions on denials? Again, very, very rarely have we had a denial, and we've had quite a few requests for accommodations come in with regards to the pandemic as well. Is it confidential? Absolutely. Any type of accommodation, because we are dealing with medical and HIPAA is 100% applicable. So it is absolutely steadfast, must remain confidential. A lot of times the supervisor will never even know what the medical condition is. Quite frankly, really should know what the medical condition is unless the employee divulges it to the employee saying, to the supervisor saying, hey, I have XYZ condition, I need A, B, and C. Generally speaking, we encourage the employee to come to HR with any medical. The medical should be submitted to HR. And then what HR will do is let the supervisor know, hey, we got a ADA accommodation in for so-and-so. They are looking for XYZ accommodation. Is this something you can entertain? Is this reasonable? Is this a reasonable accommodation? And we usually give parameters on what, just because not everybody's been through the training, I'll walk them through what a real reasonable accommodation is. And quite frankly, I will give more of my opinion whether or not I think it's reasonable or unreasonable. And then we'll have a discussion. And if we grant it, boom. But generally speaking, supervisors never know what the medical condition is, and they really shouldn't, because it is confidential. But once the accommodation is approved, you will get questions. There's dollars to donuts. You will get questions from other employees. Why is so-and-so getting, in their eyes, it's usually preferential treatment or this type of equipment. And there's an example laid out right there. Employees will ask, do I have to work the reception desk again? You never assign Jane to do it. Do not reply because Jane has a reasonable accommodation, or Jane can't sit for an extended period of time. Again, that's not a way to do it. It is departmental policies not to discuss one employee with another is the best generic answer. Again, the second one really doesn't give a lot. It's perfectly say that it's departmental policy. This is an HR issue. And trust me, HR has signed off on this, and just leave it at that. You're not getting into it, but you're not just basically saying, ignore it, go away. You're kind of giving them a little explanation. Hey, this is above, it's above board, and HR is aware of the situation. Generally, it's indirectly telling them or giving an indication of what it could possibly be without saying it. And also, it removes that kind of difficulty response from the department, basically saying, get away, ignore it. I know what I'm doing. So, but under no circumstances should you use the first reply. Second response, department policy not discuss an employee with another is acceptable. And if you want to throw a little caveat in saying that HR is aware of the situation.
Andrew, we had a question in the chat function.
Sure.
So the question was, thinking ahead, in light of the campus plan to reopen normally for fall 2021, what are some of the ADA guidelines for reasonable accommodations for individuals who might have difficulty interacting with people wearing masks, disability, or medical condition?
Great question. We have dealt with this. There are other types of masks that are now available that are clear, see-throughable. So for people that are have to read lips, it's certainly appropriate for the supervisor in that department to wear a clear mask. Even with professors, some of their students were hearing impaired, and they requested that their professors wear, well, originally was no face coverings because they had to read lips. However, we were able to grant some accommodations for alternate type masks.
Thank you.
So it really comes down on a case-by-case basis. And now, just because they have a disability and it impairs them, it doesn't necessarily mean it trumps everything else that's going on. If in this case, the employer, university, is trying to protect a large institution of people, that may trump one person's individual ADA type accommodation. So we saw this a lot earlier on in the pandemic time period, where I have a breathing disability and I can't wear a mask. Well, well, then we'll find another way, but we're not granting an accommodation to exempt you from wearing a mask due to the fact that your personal medical situation doesn't trump the close to 770,000 people that are on a campus on any given day. So there is a balancing test to that. We can find other reasonable alternatives. For example, working remotely, only coming to work when there's less people around, the ability to take the mask off when they're in their office, providing them with an office or safe place to work where they don't have to wear a mask for extended periods of time. All different options are still on the table. You would really take it up on a case by case basis to try something that fits their accommodation and something that helps the employer protect the community at large. Okay. Final thoughts. Recognize that when you have an ADA request, there's no magic words. The person doesn't have to say ADA, doesn't have to say reasonable accommodation. There are no timeframes. Just because a person has a disability and chooses to work through it on their own terms, that's perfectly fine. You may know that the person has a disability just through obvious appearance, things like that. But if they don't ask for anything, they're not entitled to anything. But it could reach a point where the employee's been working fine, just comes and says, hey, I can't do this anymore. I need X, Y, and Z to really do my job. It's getting very difficult for me to do A, B, and C due to my medical conditions. At which point we would be obligated to start that ADA interactive process at that point, even though it's been 5 years and it's never to your attention. Different things, look for ADA clues. If someone has intermittent FMLA, you may not know why the FMLA is intermittent, but you know they're struggling with coming to work on time, certain time periods. It could be seasonal, things like that. So pay attention to clues. It's perfectly fine to ask an employee, hey, I see you're having difficulty with this. Is there anything I can do to help? Is there anything you need from me or from the university to help? Return to work restrictions if somebody was out either for a workers' comp injury or a other medical related event. Work restrictions could trigger ADA. Generally speaking, ADA is long-term. So just because someone went out for a back injury, comes back for light duty and says, hey, I can't lift things over 3 pounds, and they work in the mailroom. So occasionally they have to pick up mail sacks or mail bundles. It's okay. It's not an ADA situation for a limited time period. It really doesn't fall under the FMLA, but it kind of triggers a short-term ADA request. So watch out for things like that. If there's a sudden change in performance, they were doing great, they were your star performer within the department, and then all of a sudden they're routinely missing deadlines, they're not coming to work on time, there's time and attendance issues, having conversations with them, informal, pull them aside, meet with them when they come to work and they're all in a closed, maybe not closed environment now, but even via Zoom, saying, hey, is there anything going on I need to know about? I've seen a drop in your performance. You're starting to develop some time and attendance issues. And a lot of times people will open up and say what they have going on or what's going on in their lives. And it may not be an ADA issue. More than likely, it's probably going to be an FMLA issue where they're having either a personal medical condition or someone within their household, child, spouse, is having a medical issue and needs FMLA as opposed to ADA. And again, ADA, FMLA, they are separate, but they are really closely intertwined in a lot of different circumstances. And the key thing is focusing on the essential job duties and be creative with it. But I think the first thing you have to really identify is when someone comes to you or when I come to you with, hey, someone's seeking an ADA, are they really wanting to change the essential functions, or are they looking for something that will help them perform the essential functions? And sometimes that's difficult for an HR profession to really know, and that's where really where we lean on the people that do it every day is, well, they can't really do this. Are they explicitly hired to perform this function? Or is this something they only do less than 5% of the time? And it's something they do less than 5%, it's really not essential. Please don't ask me what the threshold is for what's an essential function. Is it 10, 15, 20%? It's really somewhat subjective. It not only how often they do it, but how it not only how often it is required, how important is it? There's a lot of different factors that weigh in there. It's one of those things I kind of treat it just in full disclosure. I am an attorney by practice. So I don't like hard and fast rules, a lot of gray area. I can tell you one thing, essential duties, the closer you get to 100% of the time, the more likely is essential. The closer you are to zero, more non-essential job duties. So a lot of times it is kind of weighing out a lot of different factors. And the way I treat it is kind of the way the Supreme Court has treated pornography. I can't define it, but I know it when I see it, that type of definition.
Andrew, we have some questions in the chat function if you're ready to answer.
Sure.
Okay,
Yep.
so the first question that was sent is, if a person has a disability, what is the process they need to take to request accommodations? What do they do if they feel like reasonable accommodations are not being made or met?
What they need to do, it would be submit the documentation. If they have put the supervisor or HR on notice saying, hey, I have XYZ condition and I need A, B, and C accommodation, we should, we being HR/ER, and I say HR is more the HR liaison function, should be sending them the paperwork. And it's two forms. It's a 912 and a 913. They're available on our website. Employees can download them. I strongly encourage, even though they're available on the website, sending them a copy, whether it's an email with a link to it or sending them, printing them up, sending hard copies to be filled out. This way you have a record that the university has been proactive. Now, at that point, it is on the employee to complete the necessary paperwork to do it. If we go through the entire ADA process from requesting, interactive process, trying to find that common ground. Maybe it's not exactly what they're looking for, but nope, they rejected every advance we've made to try to accommodate them. And we send it up through the denial, it gets denied. There is an appeal process for that, which is handled by OREC, Office of Risk and Compliance.
Thank you. The next question was, how do I know if I'm in compliance with ADA in my job role?
If there's no issues, you're not aware of any type of ADA accommodations, generally it's not so much on the supervisor to be aware of anything. It usually falls on the institution, whether that's HR. Did HR do what they needed to do? Provide the documentation, listen to the issues, respond in a timely fashion. So I'd say a hard press for a supervisor to be out of compliance. The only time I can possibly think of that is you're refusing to undertake an interactive process, you're ignoring HR, but you would probably know that. So I'd say it would be difficult to do that for as a supervisor in that role.
Thank you. And then The next question is, what if the person is not meeting job expectations, but it is not necessarily due to their disability? How do I even determine this?
You don't have to worry about that. That's the good thing about this. Just because you think they have a disability and are not seeking um, an accommodation to help them, you don't have to worry about that. Even if they have a disability and they have a reasonable accommodation, they are still expected to perform at the expectation level for the position. So it doesn't give them a pass to do 90% of the work or do lackluster work, produce lackluster, excuse me, a little tongue tied this afternoon, to pursue substandard work. So if they are not meeting expectations, whether or not they have a disability, they are still subject to the normal corrective actions, whether that would be discipline, memo of expectations. Especially if there's nothing on file, you haven't been made aware of either by HR or by the employee that they have any type of or need any type of accommodation.
Thank you. We had a comment in the chat function that said disclosing confidential information would be out of compliance.
Yes, that would be. If you were to tell everyone in the department, so-and-so has a medical condition and therefore they are given this type of accommodation, or they're only expected to produce 50% of the volume of work that you are done, that would put you completely out of compliance. Yes. Not so much with ADA, that would put you out of compliance more with various other legal laws.
Thank you.
Anything further before we go? I think I have a final thought. Final thoughts. Don't retaliate. If for whatever reason an employee has requested an accommodation and you were inclined to deny it, but your decision's been overturned either by my office or by the ADA coordinator, don't retaliate. Don't take it out on the employee. That's a prime situation where you would be out of compliance. You would be discriminated against them based upon a protected class. So treat everyone fairly and treat them equally as if none of the issues exist. Everyone is the same under the law with a disability, or if they have an accommodation, they need to be treated just like everyone else. Again, can't stress this enough. Maintain confidentiality. Follow the process and be timely. Not saying you have to drop everything, someone brings it to your attention and do it, but I wouldn't sit on it for a week. I don't think it has to be something you need to report to HR within the next 10 to 15 minutes. But you have a free moment, send an email to HR. Hey, I got to talk to you about a situation that's been brought to my attention. Send them an email outlining what the situation is. You don't hear back from HR, either my office or your HR liaison, following back up with us. You're doing what you need to do. Any other questions? I am putting in the, oh, not a problem. I completely understand fire drills, things of that nature, beyond your control. I'm putting my personal work email address in the chat for anyone.
Thank you. And there's one question that was just sent into me. So I'm going to read that out loud if that's okay.
Sure. Yep.
So the question was, how do you address meeting job expectations if an employee is intermittently absent due to disability/medical? Perhaps you set deadlines, but then the employee misses the deadline. If they are hourly, it feels hard to hold them responsible if maybe they didn't have enough time to do the work.
Great question. That is something you would really need to work with my office on. I can't give you it would really come down to a factual determination. We can work through it. If it's happened once is one thing. If it's happened multiple times, well, there's a performance issue. And the key thing is they're intermittently absent. You have the interplay with the FMLAs involved. So if they're still covered under the FMLA, we have to be extra specially careful. We are not taking any negative adverse employment action because of a FMLA covered event. But if they exhausted FMLA and they're still not showing up to work, there's a better likelihood we can take disciplinary action. And by disciplinary action, I'm not saying necessarily fire them, but maybe give them a memo of expectation, a personal corrective action memo, something like that. So there's a lot of exterior factors that will factor into that. That is certainly something. Please reach out to me if you are experiencing this type of situation. Again, this is extremely common. I should say extremely common for me to be dealing with these types of situations because there is no, it's a very gray area. There's no bright line test, and it just really is kind of factoring in a lot of different things. And how often has this happened? Is this just kind of a trend to get out of doing work? So very factual, facts specific type situation, which I would be more than happy to meet with and discuss that with whoever submitted the question. I wish on that one I could be a little bit more specific on how to handle it. But I'd have to go with just a generic answer.
Thank you, Andrew. Looks like that's all of the questions right now. And thank you, Andrew, for sharing your email in the chat function.
Yep.
And I'll be sure to send that out. I will send a follow-up email. I've included a link to an evaluation survey that we'd love it if you would take a few minutes just to answer that. This will help us improve this webinar series, and we'd love your feedback of what you learned or how you feel like you might use it. And we thank Andrew for your time. I know you're incredibly busy. And we're so thankful that you decided to spend part of your afternoon with us and you could share some of your expertise and your email so that we could reach out to you should we have any questions.
Absolutely, it's my pleasure. I always enjoy doing this. I got to say, this has been one of the best groups I presented this to. I got a lot of great questions, which showed people were really engaged and wanting to do the right thing. So thank you. It was very encouraging.
Thank you so much, everyone. Y'all have a wonderful day. Thank you.